They are part of the public space, and people feel what a great thing has been done by the government. This creates a problem. That's why I.
What's why progress never creates problem.
I'm sorry.
Lack
Please
of
allow me.
offenses
All right,
do not
we get
allow
the
me.
point. We got your point. I think we have clarified it.
Yes.
That the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should enter into the.
And they have not argued equity in defense to your constitutional challenge.
That's all. That's all.
Yes.
I suppose these statements are otherwise in the public domain. In
There's
elections,
a
will
lot
be
in the public
Mr.
domain.
And therefore,
Mr. Attorney,
public
there's a
will
lot-
consume it.
Mr.
because
Attorney
of-
General, you're meeting the constitutional challenge on constitutional argument. We must address this matter like any other constitutional matter as a constitutional issue which we have to confront.
There's a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you made, that's not part of the public space.
And that
You-
Mr.
then
Sibal
you-
has also clarified, there can't be any.
That's internal.
We needn't labor this issue, we are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement on the hard cases and not one single.
Only
Yes,
one
yes, yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. But that means the right people are in the house arrest.
5,000 people. Let's not make
It's
a,
not there.
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no bunds. Why? How can there be bunds when people can't even go to hospital? People could not go to hospital because of the bun.
I
They
wish-
died.
I wish,
Not a single.
Let's not go into all this.
Mr.
I
Sibal,
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I-
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
Absolutely.
the sense of objectivity which must govern an answer to a constitutional challenge. We request both sides. Let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into the domain to try to color the mind of the judges. We have not done that. I don't know about that.
All right. Yes, Mr. Attorney.
So as I say that the famous principle versus rules and the hard cases thesis of Dworkin, one wonders we are not in a situation like this. We're leaving, taking off from what, where I left day before yesterday. There's a couple of digressions I would like to probably play before a lot before I. Because when you talk about the intent of a law, Wittgenstein, who co-authored with Bertrand Russell, and his famous philosophical investigation, he talks about a signpost. How do we know what a signpost means? There must be a practice of using the signpost and an understanding which develops over the using of the signpost. Without that practice and understanding, the signpost means nothing. So this principle has been used in various circumstances to bring closer. If there is an understanding about a law on the basis of a practice, then interpretation follows one course, one trajectory. But if there is a lack of understanding or conflict of understanding, interpretation heads in another trajectory. Therefore, when you are trying to understand the intent and connect with the content of Article 370, you have to keep in mind what went into the original author's making of 370 and what has happened over a period of time by the practice of using Article 370. So, a text sometimes, by reason of its aging and the use of the text, may demonstrate a certain practice which may show in a slightly different direction. That's why in the context of desuetude, two important principles come. A disuse plus a contrary practice. I don't get into the desuetude doctrine, it's not necessary for a purpose. I don't want to flag that. So when you're trying to understand 370 in a perspective, we have all these complexities. It's not really a case of reading the text looking at the text and the context and arriving at a meaning. We are confounded by the practice of Article 370, whether in conformity with the original intent or in deviation from it. So the court is now called upon to look at the age of the text and the use of the text and how in current times the president understands both the original text and the use of the text, and the president now understands this is what I would like to do with the text. So I left day for a study on this proposition when the president is not precluded for what I call the taking stock of what Article 370 has done over a period of time. This taking stock is written into Article 370. So while we do that, how the president may take stock and how the court will be called upon to have a glimpse of understanding of what the president intend to by taking stock. I just want to place 5-6 propositions in the context of construction against absurdity. These are all gathered from books on interpretation of statutes. Because the presumption against absurdity will, number one, avoid an impossible result.
Presumption.
It will also avoid an unworkable or impracticable result. I'll put them all together and hand it to your lordships now. And it will also avoid an anomalous or illogical result. And connected to that is to avoid a futile or a pointless result.
What is the third one you said, Mr. Attorney?
First one is
No,
an impossible result.
no, third one.
Third one, an inconvenient result. An anomalous or illogical result. An anomalous or illogical result. And the final one, I said a futile or a pointless result. All these will go into courts looking again the presumption against absurdity. So court will avoid a construction that requires a person who that which is impossible. The doctrine of impossibility, the contract is different, but when it comes to textual impossibility or constitutional text, it may stand on a different footing. That's why all these principles have a certain importance in construing Article 370. I referred briefly the other day about this presidential poll judgment of your lordships. That is 1974 to SCC 33. Before I take your lordship to the 1974, it is a 143 reference in the context of holding elections. Before I take your lordship to that, let me make a few observations. It's not part of the PDF because it's not part of the compilation.
But they are reading all the time. Yes.
So we are trying to look at the proviso to clause 3 of Article 370.
So which is the part of this judgment you want us to see? Para?
I'll give the paragraphs, your lordships.
We have it opened up and you have it on the screen.
Yeah, we have paragraphs. I'll just summarize the proposition was the presidential election had to be held. Gujarat Assembly was dissolved. Therefore, the electoral college was incomplete. So the argument was without the electoral college becoming complete, you can't hold a presidential election. Court says they read Articles 55, 54, etc., and come to a conclusion. It's a mandate that you must hold the election before the president term expires. Right. Therefore, the lack of the electoral college not being complete will not come in the way. So that unless you fulfill that impossible, that the court says you must, the argument was, you must have the electoral college completed before you hold the elections. Therefore, the
So
mandate
you're
of holding the
trying
election.
you're stretching that to our case because according to the conditions for the application of the proviso to Article 373 are absent. And therefore, the substantive part cannot be rendered into disuse merely because of the
You're
absence of the
absolutely
Constituent
right.
Assembly.
Therefore, I come to the arguments on the other side currently. Now, there is no principle in
What's the para?
jurisprudence.
Just give us a small para so we are then done with this judgment.
These paragraphs 5, 4, 5, 12, 13, 15, 20, 21, 29, and 47. So there they look at the impossibility of performance.
How
So
do
what
they,
I'm trying
how
to-
do they formulate it? Just let's see it in a moment.
I'll presently come to it.
It's 7 judges, so we can just look at maybe that one or two sentences and how they formulate it.
Give me paragraph. You'll also just see paragraph 4 and 5. Paragraph 4 at page 47 of the running page 47 of the judgment. So they come to a conclusion that the conclusion part of paragraph 4, it shows that the time to hold an election to fill a vacancy is also mandatory in character. Then,
Actually, the
paragraph 15, that's important for our purposes.
Some of this suggests. So let's take it to
Page 49, running page 49 of the judgment, paragraph 14, last sentence, and then thereafter paragraph 15. Paragraph 14, the last sentence. Sentence beginning, the necessity. Law Justice scholars got that paragraph. Only 26 pages.
stop you from. Strike all that.
Paragraph 14, last sentence.
page 14.
the sentence beginning the necessity for completing the election.
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interests, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so and so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentia excusa legem is intimately connected with another maxim of law, lex non cogita impossibilia. Impotentia excusa legem is that when there is a necessity or invincible disability to perform the mandatory part of the law, that impotentia excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constitutional Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance the way it commands you to perform.
It's like an
Yes.
29. Paragraph 21. And an argument that it shall not be done is available in paragraph 21. Your Lordship, paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assembly of the state. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assembly of the states to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It was also said that if the states were denied the right to cast votes at election, the parity between the states and the union would be disturbed. All that argument is considered, and kindly turn to paragraph 29. Again, it was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state were denied such a right, it would be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso to Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener in Articles 54 and 55, read with 368, would be a key to the interpretation of Article 62 that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state, where the Assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of dissolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state will not have an elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Kareke Supra, there are vacancies in the electoral college by reason of the fact that there are no elected members of the legislative assembly of the state where the legislative assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the president or suggesting the election to fill the vacancy caused by the expiry of the term of the office of the president could be held only after the election legislative assembly of the state where the legislative assembly is held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is at page 57, landing page 57 of the judgment.
Yes, yes, Mr. Attorney General, we've seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the president is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear, that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like, I have done my duty, therefore I exit the scene. Clause 3 still remains as an important part of reaching the exit stage. The only question is, how do you reach it? What is the more thorough way of reaching that exit stage? What consideration will weigh the president in exercising the power under clause 3? So one possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. That's one way of looking at it. Suppose we don't want to go that route. Then the president could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the president may take into account. The other way is, should I try to follow a precedent set by the president earlier by recourse to Article 367 and recourse to Article 371D? So extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the president has done that earlier. I'll come to those details. So there are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It is not a legislative function at all. Is the reference. have a key in Article 356, 1B, where after a presidential proclamation, the president can declare that the powers of the legislature it doesn't say the legislative function. So he talks about a compendium of powers available to the legislature, and that the president takes over to hand over to the parliament. Therefore, the sequence of events which was contemplated in a situation like this, where there is a void, there is an impossibility of complying with the proviso to clause 3, and how do I fill that void, if at all it's a void? I said the president could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modification. But the president does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. And once it is the non-legislative power of the legislative assembly, under 356 1B, the parliament can certainly say, I take stock of what I can do. And the parliament recommends to the president, which then we see at CO 273. So therefore, there is a sequence in which president addresses having regard to the magnitude of the problem, the importance of the solution to be arrived at, and the difficulties in handling these momentous issues facing the nation and J&K for a long period. So all the imponderables enter into the decision-making process by the president. Therefore, if a particular process is sought to be the best process, in order that any legal objection could be taken against that, is not taken. You may still find a hole in that, that's a different matter. That's how the sequence of events have taken place. So I don't find, therefore, in the doctrine of impossibility, stars one on the face, you are not paralyzed. So clause, since Article 370, the author, sometimes I wonder poor Gopal Samay, they keep talking about his statements in the Constituent Assembly. He had traveled far beyond what he thought was happening. Therefore, if we think that clause 3 of Article 370 was undergoing a natural death, I don't find any room for that to happen at all. So what happens today is, because of the age of the text, the long duration by which Article 370 has been used, rightly or wrongly, we have counsel, the petition is saying, we are reasonable authors of the text of Article 370. So on the one hand, the original author, the original intent, and its practice over a period of time, which can be given a certain understanding in construction. On the other side, we are the reasonable authors of what we will say about Article 370. But two schools of thought there. One which says 2 and 3 will efface itself out. The other says the whole of Article 370 will go, because after 1957, it can't serve any purpose. So this conundrum of two reasonable authors entering into a construction as against the intent of Article 370 and its practice to be considered on an objective basis, having regard to the purpose which Article 370 was sought to be invoked at that point of time. So all that will enter into the construction of Article 370. So that's why I say the president is not precluded from taking stock of all this. It's not really writing on a clean slate now. I mean, one has to take stock of what will happen over a period of time. You may have so many choices of action. You may have called upon to comply with certain mandatory requirements under the Constitution. You may have taken under Article 3 the view of the legislature. Very important mandatory requirements in ordinary times. But when certain other compelling circumstances which confronted the nation for a long period, the parliament, the president. So therefore, all those variables which enter into taking a final view on Article 370 have been taken in this manner. That's why I started saying